or a lack of recognition? To which the respectful answer is, it is a lack of recognition, and that lack of recognition leads to the denial of the equal protection of laws within meaning of Article 14, and NALSA para 62, which is set out in my written submission, specifically deals with that. Therefore, the lack of protection is sufficient to create a situation of unconstitutionality,
which can be avoided by reading this act.
An appropriate reading of this act. Then, minutes. Facets of 21, which further need to be highlighted, are two. My right to health would include my right to have appropriate medical decisions taken for me by the person whom I love, and so often in such situations there's an alienation. Again, we are not talking about urban families. There's an alienation from the parental family, and so in such a case, in the event of sickness, the individual is left without a person who can take responsible medical decisions, who can sign the hospital consent form, the ICU form, whatever.
No caregiver.
Lordship, please. No
legal caregiver.
No legal caregiver.
That's a 21 argument.
Lordship, please. And there's one more facet of the 21 argument. And it is this. If I am gay or lesbian or any of the other categories, then my health and happiness depend on a fulfilling union with a person of my choice.
Yes, this has been covered.
This has been covered.
Lordship, please.
The right.
And it's an aspect of mental health. It's an aspect of mental health if I am prevented from.
The point of happiness includes wellness.
Lordship, please. Lordship, please.
The fullness of one's life.
Lordship, please.
In fact, there's a whole segment in my judgment in Navtej which deals with the right to health, the right to mental health.
Lordship, please. Lordship, please. And, my lords, 25, I will only state it. And 21 also would include the right to found a family, Wills. The right to found a family, the Yogyakarta principles, we have set them out here.
Yes.
Those would also be part of my right under 21, the right to marry. If I have a right to marry, then I have a right to found a family.
Yes.
And 25, freedom of conscience. I have a right to my own moral compass. Having made these submissions, Bullets, I will come to the main area where I need to take my lords in a little detail within the time allotted.
Aspect of notice.
Aspect of notice, Bullets. Absolutely. Now, my lords, the legislative history of the Special Marriage Act, my lords, is set out from page 695 onwards of my written submission, page 698 of the PDF. Page
Why don't you
698.
tell us orally so that we'll be going through your submission?
Lordship, please,
Enough.
Lords, I'm not going to read. I'm not
Give
going
us
to
a broad
read. Yes,
perspective.
broad perspective is originally there was no codified law of marriage in India. It was all customary and religious. Then, during the time of the British, a need was felt for a law of marriage for the British in India. And so that's how legislation came. So that those provisions contemplated marriage only among Christians.
Yes.
Then comes Keshav Chandra Sen and the Brahmo Samaj. And their demand for a secular law of marriage for the Brahmos to be able to marry in, though they did not mind calling themselves Hindus. But the law at that stage, and the chronology is there, required parties to renounce their respective religions. Not being a Hindu, that was a prerequisite. Only to save time that I'm not taking, my lords,
Yes.
through the language, it's all there, my lords. That changes in 1923. When, after which you are no longer required to renounce your religion. But there is a severance of the joint Hindu family status. Which continues, that severance,
Special Marriage Act.
in the Special Marriage Act in 54 and is ultimately undone
In 1976.
in 1976. So that is as far as the law of marriage is concerned. And now let's we come to the history of notice in the context of these very laws. And what your lordships would find surprising is that they originate in a 1753 Act of the British Parliament, whose name speaks for itself. It is an act for the better preventing of clandestine marriages,
Huh.
1753. So then, Lordship, please. So therefore, a provision which originates in a preventive statute now continues through the Special Marriage Act, which self-confessedly is an enabling statute. But there these provisions are imported
Part of your written submissions is covered.
Lordship, please, Lords. Kindly, Lords, PDF 725. Then we'll come to. And, my lords, at same page 726, my lords, para 98, there is a table which has been set out giving the history of the notice provisions. And this 30 days notice is the longest ever. If you go to 1753 Act, it was 3 Sundays.
3 Sundays.
3 Sundays. Because weddings were in church, maybe that was the significance of Sundays. Now,
so the effect is to defer your right to get married at a time when you desire to.
I'm grateful,
And it can't be regarded as procedural because the impact is on your substantive right to get married at the time that you choose.
I'm obliged, my Lord the Chief Justice has summed up my argument on this. My submission is that this notice requirement amounts to the requirement of giving a notice for exercise of a fundamental right. If my fundamental right to marry is read into 21, then I can't be asked to give notice of the exercise of my fundamental rights at a future date in the context of a notice regime which is designed by the sheer length. As my Lord the Chief Justice pertinently observed, a procedural notice is different. If you say 2 or 3 days notice so that the registrar who's in some other town at least is performing other duties, keeps this day aside for registration of marriages. So that's a different kind of a notice from a 30-day notice which is designed to enable parental families and other busybodies to create roadblocks. And my Lord Justice Ravindra Bhatt, sitting as a single judge in the Delhi High Court, had to deal with such a situation in a case whose reference I have given, where the enthusiastic marriage registrar not only sent the notice to the parent jurisdiction, because if you move out, you elope, let us say, just to use a loose word, you go and settle in another district, 30 days domicile there. If you register in the new domicile district, notice has to go to your old district, your permanent district. But the enthusiastic registrars also sent it to their addresses, to their families. So the judgment of the Delhi High Court to which I am making references, the obligation is only to paste a notice, put it up on your notice board, not to inform families. And that judgment refers to the deleterious effect otherwise of this having on the freedom of choice of parties.
And if the purpose is to ensure that people do not enter into a marriage which will suffer from being void, then this is not the least this is not the least restrictive means which the proportionality test requires us to adopt.
Lordship, please.
To ensure that purpose.
Lordship, please. Lordship, please. And especially when there is adequate provision in every law, if in the Hindu Marriage Act, a marriage within prohibited degrees is entered into, the Act provides. This Act provides for penalties and punishment for making a false declaration. So it is not that people in prohibited degrees of relationship will go scot-free. But you can't postpone. And in situations like this, which we are facing, the postponement creates the possibility, the real possibility of families intervening and putting an end to the relationship. And therefore, this notice period.
Also, Mr. Ramchandran, there is a very real likelihood and not just a remote possibility that this will disproportionately affect situations in which one of the spouses either belongs to a marginalized community or a minority.
Lordship, please.
So it has a disproportionate impact on those who are the most vulnerable segments of our society.
Lordship, please, Lordship, please, Lordship, please, And this requirement of 30 days domicile. One is the notice per se, but the 30 days domicile before you give your notice. So a runaway couple has to choose a new abode, and before getting married, kindly see the problems they run into. They are not married. Which landlord will give premises on rent for those 30 days or 60 days or for however long they want to stay? Where are they going to stay in that new place of domicile, Milord?
Mr. Ramachandran, this would be equally true for heterosexual couples who propose to have.
Lordship, please, Milord. It should be struck down for all, Milord.
Applies.
This was, yeah.
Lordship, please, Milord. It should be struck down for all. It is a totally retrograde provision today.
As long as you prove that you're adults.
Lordship, please, Milord. It is both retrograde and obnoxious
Now you
to require this notice.
So only your Aadhaar card, no? Identity will carry your date
For
of birth.
wage,
And if I am correct in this submission, then what are the main provisions which need to go, and what are the consequential provisions which need to go? I'm just reading out those words.
Main provision.
5 to 8 will be the main provisions. Whose striking down we have specifically challenged. But the consequential 7 to 8 minutes. Yes. The consequential provisions or the provisions in aid which need to go would be 9, that is powers of inquiry given to the marriage officer. 10, procedure on receipt of objection by marriage officer abroad. Then 14, new notice when marriage not solemnized within 3 months. So for some reason you can't solemnize, and perhaps it's not solemnized because parents have kidnapped. So when they finally get together again, another notice. Then another notice. And finally, the provision which needs to go consequentially would be 46.
46 क्या है?
Said 5 to 10, right?
5 to 8, then 9,
10, 5 to 10.
and then 10. Yes,
On the
5
marriage
to 10
officer. On a marriage officer.
Yes, Lordship, please. I'm grateful.
40?
Then 14 also I had mentioned, but just note to 14, and then 46.
The penalty.
Yes, penalty for wrongful action of the marriage officer. Because if this notice provision goes, one of the things he's penalized for is...
All right, so we're done with item 3 now. What is point number 4?
Now, point number 4 comes straight to my last point, which is the need for the protocol. So families, couples on the run from their parental families need protection of the state through the aegis of this court. Because on the same S. Rangarajan versus Jagjeevan Ram principle, which is taken by your lordships through various judgments, if the state has the duty to ensure protection of fundamental rights, then such a protocol is necessary. I respectfully commend to your lordships the Shakti Vahini protocol, where in a parallel situation, only thing is the couples were heterosexuals. Those were community panchayats, Khap panchayats. And detailed directions have been given in para 55 onwards of the judgment of Shakti Vahini. I did not read out.
Equally, we have to be careful that in the guise of the protocol, we do not empower these officers who come into possession of information
Lordship, please.
to
To
then
leak.
use informal methods of suborning the couple. That's
Lordship.
also one thing, a danger which we have to avoid. But there has to be a protocol to protect.
Lordship, please.
Protection is sought.
Lordship, please.
Propose protect.
Yeah.
Then,
That's fine.
quickly mail.
My submissions.
Thank you very much.
I'm grateful, Bullets. I haven't exceeded the
I must
time.
compliment you for
If I may.
such precision and absolute focus. Thank you very much.
I'm
Really
deeply grateful, Mutsu.
Excuse me.
And my gratitude to my team also, Bullets, for that.
But I appear in transferred case 12 of 2023, Zainab Patel versus Union of India. Your Lordship may, my Lord, for the time being, not take the note originally filed because coming as I do in the middle order, I had one distinct advantage, my Lord, to follow the deliberations, particularly the queries of your Lordship, the responses of the Union, and the note submitted today, my Lord, encompasses and tries to answer some or all of the questions that your Lordships have posed, my Lord, and my learned friends preceding me, my Lord, who have done a very able job, have raised in the matter, my Lord.
Mr. Vishwanathan, if you could just assist us with a formulation. How
I will just formulate it, my Lord. Just give me, I have, my Lord, a written note with an index, but I just want to give your Lordship a prefatory note. I'll take 3 minutes of my own time on that, my Lord. My Lord, at the bottom of all these constitutional questions, which I have set out and answered, is the one plea of the petitioners before your Lordships here. And to simplify it, it is just this, that if we can be, my Lord, sons, daughters, brothers, sisters, brothers-in-law, sisters-in-law, uncles, aunts, friends, and partners after your Lordship's judgment, what is it that holds back from giving us that status of a married spouse, which we, my Lord, acquire and seek to acquire for ourselves, and seek recognition from the union, which union has, my Lord, wholeheartedly provided it for the heterosexual couples? The only answer is your sexual orientation, which is, my Lord, beyond my control, and the fact that marriage as an institution, as they and the majority of the heterosexuals understand, does not comport with your practices, your requirements. Hence, we would not admit you to the institution of marriage and accord you the privileges which we wholeheartedly, willingly, by enacting a legislation, accorded, my Lord, to heterosexual couples. Does that have constitutional sanction? The second answer they give is, by your very nature, you cannot procreate. If so, my Lord, I have dealt with in my note, is procreation a valid defense for negating, my Lord, the rights of recognition of marriage? And, my Lord, if we ponder deeply, which has been developed in the note,
Thanks.
which has been developed, my Lord, procreation or inability, my Lord, to procreate is no answer. None of the marriage statutes, my Lord, prescribe any upper limit for marriage. Even today, people who are, my Lord, beyond the age of, my Lord, reproductive capacity, women beyond 45 who medically may be unsafe for pregnancy are allowed to marry. There is nothing obnoxious about it. People who have decided not to have children, who cannot have children, heterosexual couples, are allowed to marry. Well, these are well settled. So, my lord, procreation is no answer. Then, my lord, does it not bring back the arguments of the miscegenation statutes, my lord, of which I have made reference? Arguments are very similar. The judgments before Loving versus Virginia, the holdings are very similar, my lord. Even the trial court holding in Loving was on the basis that it doesn't accord with our religious beliefs and the common notions of marriage. So we won't permit you to marry. But Loving said no. Because, my lord, it said you cannot understand marriage with any traditional notion that you may have. The other fallacy in the argument, my lord, is again relatable to a historical fact. My lord, these are moments in history, my lord, which we are passing. Similar instances have happened before. All that the union is saying is, everything else is fine. All other relationships are fine. You are almost equal, but you are separate. This is exactly, my lord, what was the stand in Plessy versus Ferguson.
Exactly.
I have placed passages from Plessy, except that there it was separate but equal when they segregated the classes. Here it is separate but almost equal, but separate. Don't come into the institution of marriage. We will see, my lord, the arguments of the state in Plessy very briefly and the holdings in Plessy. And we will also pay a tribute to Justice Harlan, who dissented in 1895, which got, my lord, reinforced in Brown.
Brown ultimately.
Board of Education. And also, my lord, in Loving versus Virginia on the miscegenation aspect, my lord, as to how these very arguments advance with great fervor. That, look, this doesn't accord with my belief that it has to be a certain order because it has gone on for centuries. So in that sense, my lord, this is a moment of history which your lordships, my lord, are passing through, which we are passing through, my lord. And, my lord, what your lordships are going to lay down is going to have, my lord, an important repercussions for the future. Then the further question, my lord, which has been considerably debated, which has been addressed is, do we look at it from the prism of the statute, or do we start with the prism of fundamental rights, my lord? Because if your lordships found that our claim for the union of marriage, which is the ultimate union in any, my lord, partnership, procreation and mating, my lord, are incidental consequences. If any of us here, my lord, most of us heterosexuals were to be told that what is marriage after all, it is meeting and mating of a youth and a damsel, my lord, we will laugh at the gentleman. It is certainly not that. It may be an incidental part of it. But there are much greater things in a marriage. There is, my lord, coming together of two souls. It is even addressed as, my lord, my lord, an institution which addresses the ego of the individual, where there is understanding. It helps in developing the human personality, a happy marriage. So, my lord, to be told that, my lord, it has to be looked at from the procreation perspective is completely fallacious. Special Marriage Act, my lord, is a secular law. Bommai has reiterated that before the 42nd Amendment, secularism was implicit in the Constitution. If a law like the Special Marriage Act were not to be enacted, my lord, imagine a scenario. Your lordship would have founded a positive obligation in commanding the state to enact it, just as they would not be able to repeal it today, my lord. Assume a state, my lord, to cut the notes wants to spite the face. So, my lord, we need to look at it from the constitutional perspective. The acts will have to be tailored. If there is a right, my lord, which is a fundamental right, it may fit into the statute as it now stands. It may have to be, as Fowrie said, to be tailored, to be brought in line. Your lordship may give directives. Let us not forget, my lord, we have challenged the validity of the act. It is in the process of saving the act that your lordship are resorting to these devices. The consequence would be that the act would be struck down and they would be asked to legislate, because it will be a positive obligation in a secular country like ours that you can't leave marriage between people who don't want to go the religious route to be unregulated. There is to be streamlined.
You actually sought for that as the first relief.
We have, my lord, in 3 petitions, direct declarations that the statute, which only recognizes heterosexuals union, if it is to be so construed, is invalid. My petition seeks a declaration. Honestly, an amendment was drafted, but Zainab is not well to execute that affidavit. But, my lord, that is taken care of in Ms. Grover's petition and 2 other petitions. So, in the exercise of trying to save the statute, any guideline your lordship gives, it's far different, my lord, from saying that court is being asked to legislate. Court is making an effort to save the statute in this process, my lord. So, it will not be a legislative exercise, nor can we be told that these are measures which you have to await for Parliament to enact. The Century has told us, my lord, that we have no admission to the institution of marriage. We have now come to the Sentinel on the Kavi for the same relief. And we are founding it on constitutional grounds. My lord, then the aspect of transgender, because even, my lord, in transgender persons, the 3 categories, the male manifested gender, the female manifested gender, they are entitled to maintain that manifestation. And, my lord, the trans person who doesn't manifest any gender, third gender, are inter se, my lord. Between them, a male to a male is entitled to marry, a female to a female is entitled to marry, a trans person and a trans person is entitled to marry. NALSA, my lord, expressly guarantees a right to marry. The union may say it was in 2014 before the act and in the sense of a heterosexual marriage between a trans man and a trans woman. But today, my lord, this issue and the transgender case also, my lord, involves, when you say that you are as good as any other citizen and we don't discriminate, this aspect can't be held back only because of an aspect which is nothing attributable to my fault. It is an aspect of nature. Just as you have right-handers, you have left-handers too. Just as, my lord, you have heterosexual people, there are homosexual people who have come out. It is widely, my lord, an accepted nature all over the country. It is not confined to urban, my lord, situation. As your lordship, my lord, the Chief Justice said, maybe in urban areas, my lord, they have been more emboldened to come out and, my lord, seek their reliefs. Lastly, my lord, the note addresses the molding of relief. And, my lord, I have respectfully placed 2 scenarios, the Fowry scenario, where to save the, my lord, the statute, they gave an option to amend, which they may resort to, my lord, and streamline the statute. There is another scenario, my lord, where all that is required is to read the word spouse by equalizing it, my lord, and I have placed case law for that, where you equalize them, give them that status, so that, my lord, they are on par, they proceed with their own way. My lord, it infringes nobody else's right if 2 people get married of the same sex.
So, Mr. Vishwanathan, yes. Sorry to interrupt you, but just a clarification. Since you mentioned that though there is a relief by virtue of a declaration sought by you and in Vrinda's case, you're willing to go the point of a guideline being laid by court as was being argued by your predecessor.
Yes. To save the statute, my lord. Nobody wants a scenario where the act is stuck down lock, stock and barrel, because that is the other consequence of it. So the inquiry is not that, can we do all this, can we read it? The lordship are reading it in to save the statute, not, my lord, so that it is not struck down. I go a step further. Today, it cannot be a scenario where the Special Marriage Act is not even enacted. Assume, my lord, today there is no act.
Point is, non-recognition would itself be an act of constitutionality.
Constitutionality.
And therefore, to save it, you read the statute so as to bring recognition both to heterosexual and...
my lord, this will, my lord, give us dignity, give us equality, ensure that message goes from your lordship that we are not looked upon as, Justice Albie Sachs said, as an oddity, as an outsider, as some anathema, my lord, to society, some alien, so that, my lord, we get our respect. And once your lordship pronounced, like in Johar, and my lord made that point on the first day, it percolates down to the society, my lord. There is acceptability. Court has said so. My lord, our society is a law-abiding society, my lord. They'll know, oh, this is a point of view, and your lordship reason it out, and that reason percolates. That's how it is accepted, my lord. Today, why is basic structure, my lord, accepted? It is founded on a sound reasoning, my lord. It's 50, 60 years now, nobody has been able to dislodge it because your lordship's institution gave sound reasoning to it. So all that is required is a message from your lordship, assuming your lordship accept it. In this, my lord, background, just see, my lord, my note. So I will now, my lord, I have extracted most of the paragraphs so that reference to the volumes, my lord. I just want to, my lord.
Then I think you've covered it very comprehensively in what you said. You were
I just
curiously typing away when you were arguing. So I think
I just want to, my lord, since something has been put down, use the time that your lordship gave. My lord, when there was a grim scenario when your lordship debated the time, I wanted to mention your lordship recollects the 4th book of David Panic.
yes.
It came this way. The US judge asked the lawyer, how long are you going to take? He said, don't worry, you're not allowed to move my car because in US after 20 minutes he'll be charged for parking. Now, the only reason I didn't say that was your lordship should not now charge us for parking. That will be a way, my lord, where we cut down our time.
Thanks for the idea.
Someone else pays. Someone else pays for it.
But my lord, the book is titled A Collection of Articles published by Dr. David Panic in The Guardian. Is collected in beautifully written short pieces. I had to move my car.
Who moved my car?
The judges. The earlier one was judges.
Judges, my lord. Judges and advocates.
My car is a beautiful.
Very, very, my lord, a delightful read.
I have a
Speaks about a tourist guide.
10 to me, you know. Beautiful.
Speaks about a tourist guy walking past his office. Make the best use of my time. My lord has the note called, my lord, loaded today. My lord, we are not sure whether it will be loaded.
Marriage and choice begins with that.
My lord, that, only one line from that.
No, which note are we looking at?
That, kindly come to my lord Carlos Ball. Sorry, my lord. My lord, we have, my lord, I know your lordship detests hard copies. I have a soft copy, but I also, my lord.
I have a soft copy.
Very
Just one, Carlos.
Just see page 4, my lord,
Page
Carlos
1.
Ball.
Carlos Ball. Right, got it.
Yeah.
Not this one. Not
My lord, may I give a hard copy to you?
Something from what was earlier.
Yes, my lord. My lord, after your lordship's queries,
Yes, ma'am.
One Goodrich versus Department.
Goodrich versus Department, my lord, some of them are culled out from cases cited in Fowry. Some independently, my lord, my team has, my lord, been able to collect.
First 10 to 12 pages you have covered as to the meaning of marriage.
Yes, my lord. On marriage and how, my lord, it is.
Quoted Martha Nussbaum also.
Martha Nussbaum is quoted, my lord. A learned friend, one of them was very exercised, my lord, leading and a treatise already quoted by your lordships in Navtej. I will, my lord, very selectively read so that my learned friends are not hard pressed for their time. But I'll make the use of my time. Yes, my lord.
This is after volume 4.
This is compiled.
पहले आप
One second. Mark it. I'm not going to read it. Page 4. Carlos, Morality of Gay Rights, Carlos Ball, on how, my lord, constitutive elements of personhood get its full blossoming when the marital union, my lord. As your lordship come down the italicized portion, page 4, my lord. The public recognition, when it is accompanied by social support and encouragement, makes it more likely that the relevant responsibilities will be met. The structure that marriage provides, the obligation that it requires, then can strengthen and make more durable the affectional components of sexual intimacy that are characterized by ongoing commitment and mutuality. The socially recognized marital relationship can provide the structure through which the well-being of the partner becomes inextricably linked to the well-being of the self. fundamental to it, my lord, is the choice, as my lord, my learned friend Ms. Tara, my lord, wants me to emphasize. The aspect of choice put in bold letters, my lord, through the first 4 paragraphs.
Yes.
My lord, Goodridge said yearning for security, safe haven and connection has expressed our common humanity. My lord, this is to remove it far away from, my lord, the procreation part which was highlighted. My lord, kindly come over the page on the aspect of, my lord, the equality code, how only one form cannot be determinative. My lord, Fowrie, one important passage Dr. Singhvi placed in his note, my lord, but just see the para 13 before the extract, my lord. The South African Constitutional Code felicitously explained that equality does not imply the leveling or homogenization of behavior, but rather it lies at its core in the acknowledgement and acceptance of difference. The court further explained that equality requires persons to be able to accommodate the expression of what is discomforting.
What like free speech?
Yeah.
Yes, my lord. My lord, kindly mark PDF 2044, my lord, there. In case I have just marked it, but I am not, my lord, going there to read it because these are words from the judgment. PDF 2044, volume 4 of the case law compilation. It is humbly submitted that the petitioner's case before the Honorable Court requires a similar conception of equality. The efforts made herein are for social acceptance and for the citizenry to ultimately acknowledge and accept the difference and to accommodate for the existence of the LGBTQIA plus persons in the same way in which heterosexuals lead their lives. The interests of the heterosexual persons and the LGBT persons do not collide. They coexist in a constitutional realm based on the accommodation of diversity. My lord, that is PDF 2068. My lord, over the page 8, para 16, only because the union says we have prescribed age restrictions, we have prescribed prohibited degree. But they are founded, my lord, on solid, my lord, grounds of health. Kindly see, my lord, how we have addressed it from line about 4 in para 16. In this regard, it is submitted the same is a defense which is the nature of purported facial equality and ought not to be accepted by this court, whereas the restriction of certain class of heterosexual persons from being married, such as minors or other forms of prohibited relationship, directly relate to the state's power to restrict the said marriage on the grounds of either health or such other acceptable grounds. My lord, much was debated on how to apply part 1, part 2, will it be reading in, etc. My lord, till the legislations are streamlined, there is a principle of rule of interpretation. Principles analogous thereto will apply, my lord. Your lordships have extended it in the Limitation Act for courts and tribunals. So apply principles analogous thereto till such time the legislature is streamlined. Your lordship may not want to say both will apply. That is a good suggestion. It has to be accepted as a guideline, as the Honorable Justice Kohli said. Otherwise, principles analogous thereto will apply, my lord. Prohibited degree is, my lord, a established way. It is a health ground. It is scientifically believed that, my lord, the progeny will be
Health, not only biological.
not only biological.
Prohibited degrees goes beyond biology.
Yes, yes, my lord.
There is an element of social and state prohibition.
But they are justifiable, may not apply across the board. I am only saying how to apply it to this spouse category, which your lordship will now add in. Principles analogous thereto, my lord. Nobody can say that that can't be extended. My lord, I have dealt with procreation and childbearing, but I have explained it to my lord. Till today, no upper age limit on marriage. Kindly see, my lord, how the first of the judgments in South Africa, the National Coalition for Gay and Lesbian Equality, my lord, put it. Immigration was denied to, my lord, same-sex partners. Fowrie came in 2005. Just I'll read page 11. One second, Anuj. From a legal and constitutional point of view, procreative potential is not a defining character.
Adoption denied to same-sex couples who were recognized by law.
Yes.
Fowrie was.
Fowrie, my lord, was a same-sex marriage.
Same-sex marriage was recognized by law. And yet what was denied was adoption rights.
Very good.
Adoption.
Well, correct it. No, my understanding was marriage was confined to the common law definition. The lower court had pronounced.
Same-sex
Yes.
relationship.
Here, my lord, the case in 99 was, under the Aliens Act, immigration was confined to married couples in the heterosexual sense. And the defense was of, my lord, inability to procreate. From a legal and constitutional point of view, procreative potential is not a defining characteristic of conjugal relationship. Such a view would be deeply demeaning to couple, whether married or not, who for whatever reasons are incapable of procreating when they commence such relationship or become so at any time thereafter. Likewise, demeaning to couple who commence such a relationship at an age when they no longer have the desire for sexual relations. It is demeaning to adoptive parents to suggest that their family is any less a family, and any less entitled to respect and concern than a family with procreated children. I would even hold it to be demeaning of a couple who voluntarily decide not to have children or sexual relation with one another. My lord, constitutional law is tested on the anvil of a common parlance test, my lord. Our own society, there were times, my lord, when people would repeatedly ask, is there any development on the marital front? Today, my lord, it is considered bad etiquette. And our memory is short. There was a UK prime ministerial candidate, I got the news item, who opposed Theresa May and made a deadly statement that she is no mother. What does she know of administration? She had to withdraw her candidature, my lord. Andrea Leadsom. That is the, my lord, sensitivity with which people have arrived. So this is no issue at all. Surprising that, my lord, it was argued with such vehemence. The candidate withdrew from the party contest before May was elected on this ground, my lord. Andrea Leadsom is only illustrative, my lord, as to how society all over has changed. Our society has changed, my lord. My lord, Obergefell on the point that, my lord, you can't see marriage through the narrow lens of procreation. Yes. My lord, there is one important aspect which